another Bailiwick Legal Facebook Live. My sincere apologies for the delay with this one. I had thought that I had been recording for the last 10 minutes, but it turns out that I have had some technical difficulties, so let's try again. Today we're going to be discussing alternative dispute resolution clauses. So before I get into it, just a general disclaimer that the information is provided in a summary and overview form, and its publication doesn't constitute legal advice, and you should seek your own legal and other professional advice before acting or relying on any of the content. So we'll start by talking about what is alternative dispute resolution, and throughout this talk I'll refer to alternative dispute resolution as ADR for ease. So ADR is the term typically used to describe a wide range of dispute resolution processes and techniques that parties can use to settle disputes, and this is often with the help of a third party. So ADR is often used as an alternative method to legal proceedings, and it can be utilised for all types of disputes ranging from small debt claims to large commercial disputes. Some examples of ADR processes include negotiation, mediation, expert determination, and arbitration. So what is an ADR clause then? Some contracts will incorporate ADR processes by having an ADR clause incorporated into the contract. An ADR clause will be a provision by which the parties agree that they will seek to resolve any disputes arising under the contract using the ADR processes. ADR clauses can be elective, so they're non-binding on the parties, or they can be mandatory, so they are binding on the parties. ADR clauses have become quite popular in many commercial contracts because they reflect the parties' mutual desire to consult and negotiate rather than to litigate. An ADR clause can define which processes are available to parties if a dispute arises, and similarly it can also clarify or define which processes are not available. Not all disputes may be covered by the ADR clause, so the clause should also set out what disputes can invoke it. It's really important that ADR clauses clearly define what processes will or will not be available or applicable, and also for what disputes. If it's not properly drafted, then it may be void for uncertainty and will therefore be unenforceable. So what are the advantages of ADR? There are many advantages, and these include that it can be more time effective. So often disputes can be settled in weeks or months as opposed to months or years like with litigation. It can be more cost effective as well. So where disputes are resolved early through ADR, parties will often save money that would otherwise have been spent on court fees and lawyers. It can result in increased control over the process and outcome, so parties will typically play a greater role in shaping both the process and the outcome, and in a less regimented or formal manner. It can preserve relationships, so it can be less adversarial and hostile, which can help preserve relationships between parties. And it can result in increased satisfaction, so it can help the parties to find a win-win situation and achieve their real goals, as opposed to litigation where sometimes there's thought to often be a winner and a loser. What are the disadvantages then of ADR? So some disadvantages can include that there can be unequal negotiating. So in some situations, one side is capable of having more power over the other, which creates an imbalanced negotiating platform. There can or most likely will be limited expertise. So where an argument does involve complicated legal points, the third party involved is often not likely to have the knowledge and proficiency to properly articulate the position. Enforceability. So some forms of ADR are not actually binding. So even if an outcome is reached, it may not be legally binding on the parties, and therefore there may be limited recourse or consequences if the outcome is not actually abided by. This can obviously lead to time wasting, as the parties are then forced to engage in litigation or other processes to obtain a solution to the dispute. It can still be costly. So even though ADR may be more cost effective than litigation, there still is a significant cost involved, as the parties do have to pay the third party for their time and other associated costs. So a well-drafted ADR clause can give parties in dispute a better chance of reaching a favourable resolution and preserving their relationship. However, a poorly drafted ADR clause can lead to further issues and ultimately be less time and cost effective. So whether or not an ADR clause should be incorporated into your contract will depend on the particular circumstances and the nature of the contract. Hope this has given you a little bit of information as to what alternative dispute resolution is and how alternative dispute resolution clauses can be advantageous or disadvantageous. I hope you all enjoy the rest of your Wednesday and try and stay dry. Join me for my next video, which will be on the 21st of September. Bye.